Okay, well, I'm going to go ahead and get us kicked off. Welcome, everybody, to this is our second session of the North Carolina Evictions Update with Chris Loebsack. I want to thank all of the affiliates here in North Carolina for coming together to help pull this together. I know it's an area of information that all of our members have been really screaming for more information, and so I think this is going to be a great help to them. Also want to specifically thank Triangle Apartment Association and Meg in particular for being the brains behind this operation and getting the Zoom set up. Like I said, we're all new to this, so be a little patient with us if it's a little glitchy, but I think we'll still get everybody taken care of today. As we mentioned before, you can submit questions using the Q&A button there on the Zoom panel. We will try to get as many questions answered as possible. We're going to begin with, Chris is going to kind of give an overview. There are 5 documents that he's going to reference that Meg is going to put links to it to those documents in the chat section. So you'll be able to reference those directly. She will also share her screen so you can see them while Chris is speaking. Again, we're new to this and we're going to do the best we can. And a final reminder, this will be recorded and the link will be available later today. We'll send it out to all the attendees. All right, and it looks like those links are in the chat box if anybody needs to take a look at them. And I believe that's it, Chris, so you're on.
John, thank you very much. You do an excellent Dustin impersonation. Everybody's getting the hang of this pretty quickly. Meg, thank you for setting everything up and being the lady pulling the strings behind the scene for us. To everybody that's out there in Zoom land, hello and good afternoon, and thank you for taking the time to join us. I know that if you're like everybody else that has my email handy, you have a million questions about what's going on, and I have about 600,000 answers for those million questions because there's still a lot of stuff that we don't know. But I decided that once we started this, it makes sense to keep doing them at least periodically because, as I suspected, yesterday we had a new piece of information come up. So we might as well add it to our list of things to talk about today. But for those of you that weren't able to check in on last Friday's seminar, I'm still going to start from the beginning, and that way we don't miss anything for anybody. As most everybody knows, on March 10th, Governor Cooper issued a statewide order declaring a state of North Carolina emergency, and that gave him and gave power to other branches of the government to issue orders under the state of emergency statutes that exist in most every state. In the event of an emergency like this, the government gets special powers that allow for it to take emergency actions that don't require the usual set of bells and whistles or legislative actions in order to take effect. They are emergency actions like that are only allowed for temporary reasons during temporary periods of time, and that's the balance that is struck, allowing the governor and other branches of the government to take immediate action that doesn't have to be approved by the entire legislature. So after the March 10th order from Governor Cooper, the state Supreme Court, Chief Justice Cherie Beasley, just a couple days later on Friday, March 13th, issued her own order, which Meg can put up on the screen and we can talk briefly about. But one of, there you go. But one of the powers that is given to the judicial branch of government in a state of emergency in North Carolina is that the Chief Justice of the Supreme Court is allowed to issue such orders as are deemed necessary in the Chief Justice's discretion to ensure the effective, safe, and efficient operation of the court system throughout the state during the state of emergency. So in that context then, the order that she issued on March the 13th basically gives you a list of emergency directives. There are 2 emergency directives that she put into her order. That one's emergency 2 that you see on the screen. Emergency 1 was just before it. But the short version of each of those directives is that as of Friday, March 13th, the courts of the state of North Carolina were to continue all pending matters that required hearings before any branch of the judiciary. The original scope of the order was contemplating district court and superior court actions. It made exception for trials that were already in process being allowed to be finished, and certain other small exceptions. It did not specifically say one way or the other what the effect was on magistrate hearings or the continuous hearings, except that it allowed for the local district court judges to make further decisions about what they believed was capable to be done at their courthouse, and so gave some power for them, gave them a little bit of leeway to try and figure out what kind of conduct of business they were going to continue. The order specifies that the courts are to remain open for business in this state. The exact hours and manner in which they conduct business is open to the county clerk of court to determine, since the county clerk is in charge of and hires and supervises all of the courthouse employees and staff. So each county clerk of court is responsible for ensuring the operation of their courthouse in a safe and efficient manner. The big issue then was, what does this mean for all of our cases? So come Monday, March the 16th, everyone wanted to know, what are we supposed to do? Do we have court? Do we not have court? If we do have court, where? Which cases are being heard? And any number of other questions were left unanswered. The primary thing to keep in mind, though, is that this order and the subsequent orders do not close the courthouses for business. They require that hearings be continued for a period of at least 30 days. And so that meant that the existing hearings would be continued for at least a period of time no sooner than April 17th, and that all new cases that needed to be filed, eviction or otherwise, would simply be brought to the courthouse, filed, handled, and assigned a hearing date that occurred sometime after that 30-day deadline, since the court said it was not going to conduct business before any earlier than April 17th. So what you have seen in the intervening weeks is that cases have still been filed, cases are still being handled and processed by the courts. They're simply being assigned hearing dates that are some period of time after April the 17th. Generally speaking, they're being placed in order, just like they are on the regular course of business. And so the cases that are filed first got hearing dates the closest to April 17th. Cases that are being filed later are being assigned dates that are now into early May for most counties. There isn't yet any directive as to how the court's going to conduct its business after April 17th. And in fact, there's not any real certainty that the court is going to actually open for business on April the 17th again as normal. If you're paying attention to the news, I think there's real good reason to believe that the court very likely will not operate business as usual on April 17th. There's still reason to hope that maybe there will be business at the courthouse on April 17th, but I highly doubt that it will be business as normal. So after that order went into place, a whole bunch of questions got asked, and everyone wanted to know, how are we going to do business? What does this mean for magistrates' courts? And so then over the weekend, Chief Justice Beasley realized that there was a need for further clarification of this order, so she issued another one. Sunday evening, March the 15th, document number 2 that's in your notes here got issued by Chief Justice Beasley. It's a memorandum that she wrote in conjunction with the director of the AOC, McKinley Wooten, and in essence, it provides some clarification. So if you read through the documents here, you'll see that yesterday the governor issued an executive order that was on Saturday the 14th, prohibiting gatherings of more than 100 people and directing the closure of all K-12 public schools for a minimum of 2 weeks. Well, once you do that, it makes it pretty clear that it would be very hard to operate the courthouse if the governor has said that we're not supposed to be congregating in a 100 people or more category, because most anyone who's ever been to the courthouse, been to magistrate court specifically, recognizes that it's pretty likely that there's going to be 100 people if you're running dockets at Mecklenburg County, where you have sometimes 200 cases scheduled for the same hour. even though most of the tenants don't show up. If you're running 3 courtrooms right next to each other, you're going to end up with 100 people no matter what you do. So Chief Justice, in response to that order, felt like Director Wooten and she needed to address that issue. They had a meeting on Thursday, and she goes on to state in the bottom paragraph here, it says, while at this time our courthouses must remain open to accept filings and address emergency and safety situations, things like domestic violence protective orders, for example, are always allowed, and there are hearings being conducted to address those to make sure people stay safe. The spirit of her order is to drastically reduce the foot traffic in all of our courthouses across the state. So if you keep reading on the next page, the public's minimal presence at courts will help reduce community transmission, and so the NCAOC is working to complete response to a number of frequently asked questions, but she wanted to cover some of them here for at least the next 30 days. 1, in-person meetings must be postponed or canceled to the fullest extent possible at the courthouses. That's why you'll see most courthouses now have we're not interacting with you at the window, we're only interacting with you through a box. You can push your documents in the box, we'll review them, and we'll let you know if we need to talk to you. But in-person meetings are discontinued, so the windows don't operate as they used to. When cases or hearings cannot be postponed to the next 30 days, remote technology should be utilized as authorized to the fullest extent possible. So that if you have an emergency hearing that has to take place, the courthouses have permission to do that electronically by Zoom meeting, for example, if they want to. Matters before the clerk of superior court, those are specific and unique and don't usually involve eviction cases at all, but then matters 4, or item 4, matters before magistrates, very clearly specifically spells out that magistrates must conduct initial appearances in criminal matters and, subject to health precautions, should continue to perform weddings. But then small claims proceedings, including summary ejectments and money owed cases, must be postponed. And then 5 is district court, where you sometimes have tentative appeal cases. So all civil and criminal and superior court matters that are not subject to the exceptions set forth above, including traffic court, must be postponed. So if you had a tenant appeal case that was already in process, it's just as postponed as all eviction cases are by virtue of this order. So the short version of a much longer story is that before we got to Monday, the 16th of March, the Chief Justice had responded by clarifying that all magistrate matters that were pending had to be continued, which is what you saw come Monday. One word of this order got around to all of the clerks. There was actually a couple of clerks that didn't realize the order had been issued since it came out late in the day on Sunday. And so we heard that there were actually some court hearings being held, but those got postponed by request of a legal aid attorney or similar. Once they realized that that's what was going on, the clerk read the order from the Chief Justice and postponed everything. So all of that is to say that as of Monday the 16th, a week ago Monday, all eviction matters are at this point postponed. If you had a hearing already scheduled, it was pushed out. For the moment, they're pushed out indefinitely because the clerk doesn't know where, when, or how they are going to actually get those things rescheduled. That is a matter that each clerk will likely have to do in their own county based on their own county process, procedure, capabilities, staffing loads, case loads. There's almost certainly going to be a wide variety of approaches that are used by the various clerks in the 100 counties of the state to address whatever backlog they might have had as a response or in response to this order from the justice requiring that all cases be postponed for 30 days. So I wouldn't be surprised at all if we see very unusual things start happening when we get back to courthouse business, whether that's April 17th or after. I think you should likely expect that hearings may occur at all hours of the day for a period of time so that they can tackle the backlog of cases. You may see courthouses operating all morning and all afternoon for a period of time, with the magistrates just scheduling as many. In Mecklenburg County, the magistrates have a docket of 3 one-hour dockets every day. I wouldn't be surprised at all if we saw 3 afternoon dockets be added on for a period of time to address this. I wouldn't be surprised if we saw some clerks of court tinker around with the idea of night court, perhaps. 6 o'clock courthouse dockets may be something that they have to use to try and tackle the backlog of cases. it just remains to be seen, and no one is giving any directions yet because no one is quite sure when any of this is going to start in the first place, April 17th or otherwise. And there's certainly still quite a ways to go between now and April 17th, no matter what we have happen. So I think there's reason to believe that this will be a very fluid situation that we probably won't find out about for sure until very, very close to the end of the window of time, unless we get some more clarity from the governor in the interim. So that made clear that the courthouses are still supposed to be open for business. They're still supposed to be accepting new filings. They're still supposed to be taking new cases, which they are in North Carolina. In addition to that, we also then had a development just a couple of days later. Document 3 came from the federal government. President Trump, during one of his press conferences that week, made mention that he and the director of HUD had been in contact with each other, had been discussing, and were waiting for an order to come out from the Department of Housing and Urban Development to address eviction-related issues. And this is the order that they put out. This came out, I believe, on the 18th, maybe the 17th. Oh, there it is, March 18th. Yes, Wednesday, March 18th. And in this one, director provided that all foreclosure actions and all eviction actions nationwide would be suspended for 60 days, but only for properties that are A, single family properties, so not multifamily properties, and B, only single family properties that are financed by an appropriate vehicle of the federal government. An FHA insured mortgage is the trigger that he lists in his agreement here. So if you are a multifamily operator, then Director Carson's memo doesn't apply to you at all. If you are a single family property management company or a property management entity that has both multifamily and single family components, then you need to be checking with your owners, who are your clients, to find out whether any of their single family residences are in fact financed by FHA insured mortgages. Because if they are, then you must set those particular properties aside, and the owner may not evict anybody from that property no matter what for 60 days. That is a question that each property management company needs to be asking each of its owner clients before submitting any documents to the courthouse of an eviction action. You would not want to be filing evictions in violation of a federal order. It would be a defense that could be raised by the tenant at a hearing whenever hearings start again, but more importantly, it would also likely subject you to some serious PR that you don't want to get. I think anybody that would find out that you had filed a case in violation of the federal order would love to make that a news story. So I think it's highly advisable that you play far, far away from this line if you are in the operation of a single family portion of any portfolio. I think those folks should be very cognizant of this and stay far away whenever possible. So the next item, after we talk about that, the federal HUD memo, the next thing that happened last week came on the 19th. That's a second order from Madam Chief Justice, and this one also made clear that we have more things going on. So the order here was designed to address issues that deal with what happens if during the April 17th, while we wait for April 17th, what if I have a deadline that I'm supposed to deal with? What if I had a case that was heard on Friday, March 13th, for example, in eviction court, and so I have a 10-day window to appeal, and I have an obligation to file that appeal with the court within those 10 days, but the courthouse is limiting its business to periods of time when I'm not able to get there. Court in Mecklenburg County, for example, is only operating during a limited window of time. The court in Wake County is only open from 1 to 5. Mecklenburg, I believe, was 9 to 12 or 12 to 5. And so the Chief Justice realized that that may be a hardship since courthouses were limited the hours they were open. That may needed to have been addressed. And so she issued this order on the 19th to make clear that all, you'll see right there, right in the middle, the extension of time, periods of limitation, and periods of limitation pursuant to NCGS 7A-39. What that says is that the Chief Justice was declaring that any time period that would have expired during the period through and including April 17th was being deemed waived by her, so that any deadlines that occurred during the period of time through and including April 17th are going to now be deemed legally to have occurred no later than April 17th. So what that means is that if you had, technically speaking, 10 days to appeal an eviction order or eviction judgment that was entered while the courts were still open on Friday, February 13th, normally that would have been your obligation to do that by yesterday, Monday, May the 23rd, or sorry, Monday, March the 23rd. And instead, you now have through and including April the 17th to file that appeal, and it will be considered timely. If you do not file it by the 17th and instead on the 18th it's not been filed, then your appeal will have expired. But all things that have a deadline now are considered timely filed and are considered to have been satisfactorily filed if you comply with this order now that it's been entered. It gives everyone basically a period of a window of time through including April 17th to take whatever legal action they were supposed to have taken in the intervening times. One of the other things that comes up is there, go to the second page, would you, Meg? Yep, there you go. And so this order does not apply to documents and papers due to be filed or acts due to be done in the appellate courts, and additional emergency orders or directives under the statute may be entered as necessary to support a continuing operation of the central court functions. So that means that the Chief Justice is reserving the power to modify this order again, if need be, this week or next or the week after, depending on how things transpire. What it really does, though, is it throws into some confusion the issue of what about writs of possession that are allowed to be filed based on hearings that happen on Friday, March the 13th. So today, on Monday the 24th, technically speaking, new writs should be allowed to be issued. But the problem is that those new writs are likely not going to be able to be filed because, technically speaking, if an appeal was due yesterday, but now the appeal is timely as of April 17th, then a writ is uncertain. The entitlement to have a writ is unknown today. And so what a lot of clerks are doing is they are refusing. It's sort of a 50-50 split based on what we can tell right now between clerks that consider the matter to be proper, and so they issue the writs, but the sheriff is not going to execute on it until April the 17th has come and gone, so that we know for sure whether an appeal was ever filed or not. And other clerks who are just simply saying, we're not going to file them at all, we're going to wait until April the 17th to find out if an appeal was filed, and then we'll issue writs after that. But the short version of a long story is that if you didn't have a writ already in place before that order got entered, it's unlikely that you're going to get an execution on that writ, whether you get the writ issued or not. You're not going to get a lockout done until at least April the 17th, pretty much anywhere. We've had a couple of sheriffs even go further than that. Wake County and Mecklenburg County in particular have wanted to avoid and wanted to make a big public statement about them not wanting to evict people, even though that's actually their job. And so they're trying to hold press conferences to say that we're not going to enforce writs even if they were validly issued during this time of crisis. The Chief Justice said they had to if the writ had already been issued, but then this order popped up a week later. And so as of March 19th, we now have at least those two sheriffs and a few others that are taking the position that even if you have a writ and even if it was in line for a lockout, we're not going to perform the lockout because we read this order to say that all actions that were supposed to be taken under law are timely done if done before April 17th. So lockouts may not be done even on a writ that you got issued on Friday, the 13th of March, until close to the April 17th deadline. The sheriff has a deadline. They have to execute the writ within 5 days of being provided the writ. And so the sheriff in those two counties is taking the position for now that their 5 days is just like anybody else's 10 days to file an appeal. And as long as the sheriff does the execution by April 17th, they consider themselves to be timely. Madam Chief Justice has not provided clarification for us on that. A lot of us think that's bunk, and it was intended to cover the parties to proceedings, not to cover the sheriff, to allow the sheriff to not do its job. But unless and until Chief Justice Beasley clarifies herself and makes clear what the sheriffs are or are not required to do and when, right now we have sort of a stalemate in a couple counties where the sheriffs are just holding writs and not doing anything about them. And there's not really much anyone can do about it, since Madam Chief Justice is in charge of the courthouse proceedings. Absent a directive from her, we're not going to get a lot of clarity, or until she gets around to issuing a clarifying order, we're not going to really know much more, other than some counties are taking it upon themselves to just say, look, we're not going to issue writs that we know aren't going to be executed yet. And so I expected you'll have some writs that we'll just have to hold off until April the 16th before they get issued, or something like that, so that they're in compliance, and wait and see if the April 17th deadline actually sticks. Because if it doesn't stick, then everything's subject to being pushed back yet again at any time, either by directive from the governor himself or from Madam Chief Justice in response to an order from the governor. But everything is currently in a continuing state of flux and changing. Every second day or third day we're getting new information, and that's why we keep holding these webinars, because there's new stuff to report every time I turn around. And then the final document that we've got for everyone to look at is the one that came out yesterday. So there's a news release from the federal government yesterday. The FHFA, which is the parent entity that governs Fannie and Freddie, they yesterday announced that they were moving to provide eviction suspension relief for renters in multifamily properties that are covered by an FHFA mortgage. So again, it's limited in scope. This one is a little more broad than the other. And it essentially says that if you are a property, a multifamily property that has FHFA mortgage funding or financing, then you are able to request and receive a waiver of your obligation to pay your mortgage payments during this time of crisis. But in exchange, you have an obligation to agree to not file an eviction or to suspend all eviction proceedings. Where's the language? For the entire duration of the time the property remains in forbearance. The forbearance is available to all multifamily properties with an enterprise-backed performing multifamily mortgage that is negatively affected by the coronavirus national emergency. So the government basically said, it goes on to say, the renter should not have to worry about being evicted from their home, and property owners should not have to worry about losing their property or their building due to the coronavirus. So the multifamily forbearance and eviction suspension offered by the enterprise, which is Fannie and Freddie, should bring some peace of mind to millions of families during this uncertain, difficult time, said the director. The enterprises are working with mortgage servicers to ensure that these programs are implemented immediately, so the property owners and renters experiencing hardship because of the coronavirus get the assistance they need. Yeah, there you go. So the suspension has to be, and the language is right at the top of the screen right now. The forbearance comes with the condition that the multifamily operators suspend all evictions against renters who are unable to pay rent due to the impact of coronavirus. So that's the key. It's not only is it a limited order from the government based on what kind of mortgage you have, but it's also a limited suspension so that you don't have to stop evicting everybody from your community. You don't have to agree to allow people who have jobs, who are still receiving their same paycheck as before, who aren't covered by this, people who are in an essential service provider position or who are otherwise still making all of the same income they made before because their job allows them to work from home and they haven't suffered any loss of income at all. You don't have to give those people a free pass. You only have to give a free pass to residents and suspend evictions against residents who are, and the language is clear, unable to pay rent due to the impact of coronavirus. So you've got a number of things there that if you are one of these properties that's covered by this mortgage, you're going to be looking at setting up some sort of step-by-step analysis to determine who is and who is not subject to being filed on in the coming months. And so whether you choose to or not, you will have the opportunity anyway to seek the forbearance for your property so they can hold off on its mortgage payments for the time being. And then in exchange for that, you'll have to put together a protocol of some sort that allows for you to determine whether a particular resident meets this definitional criteria: unable to pay rent due to the impact of coronavirus. Not unwilling to pay rent, not able but skeptical, not able but trying to be conservative and save their money, but unable to pay rent and due to the impact of coronavirus. So you'll have to also see things like change in income and change in employment status, reduction in hours. All of those sorts of things will be part of the analysis that has to be done to determine who does and who does not get filed on at your property, who is and who is not, which residents are and which residents are not allowed to seek some safe harbor under this provision. And of course, this is brand new since yesterday. There's very little continuing discussion yet. I haven't seen anything come out today that provides any clarification or further information about this. So you're reading it the same as I am. How you implement it, whether you're allowed to implement it, those are all questions that you're going to want to in touch with your friendly neighborhood lawyer and talk through in great detail before deciding how and whether to proceed in some fashion or another with this new guidance. So that's all of the news that's fit to print so far. One of the other issues that's of common concern for everyone is the shelter-in-place order issues. As you know, Governor Cooper yesterday issued a new order that clarified that schools are going to be are not going to resume until the middle of May. He did not issue a shelter-in-place order. He ordered the closure of a number of categories of businesses that involve personal interactions that don't meet the criteria of social distancing, barbershops, hair salons, nail salons, fitness centers, any number of other things. But he has not ordered us to shelter in place at this time. You may have seen an email earlier today that came out from TAA, I believe, with some information about how to send an email to the governor's office requesting that your category of business be included in the list of essential businesses in the event there is a shelter-in-place order that becomes necessary, but allows for essential businesses to continue operation. That's an important one to keep in mind. In all likelihood, the multifamily industry would be deemed essential under most every circumstance. Most of the orders that I've seen include in the list of essential services people who provide shelter for others. So that would include hotels and apartment operators and other things. So I don't think that's a grave risk. TAA has already sent a letter on behalf of or AANC sent it on behalf of the industry requesting that clarification, making sure that everyone knows that. But for the time being, those are the issues. If the governor does issue a shelter-in-place order, it will almost certainly have some impact on the issue of continued filings of eviction cases. In every scenario I can envision, the courthouse staff will be deemed essential. Courthouses are not generally supposed to close. They are supposed to stay open for business, and I think our governor has a very strong commitment to that idea. So we shall see, but knock on wood, that hasn't happened yet. So those are the things that most people are continuing to pay attention to and worry about. Now, on to a bunch of questions that I have and try and knock those out, and then we can take some from the audience too, I think. I think Meg is fancy.
All right. Well, thank you, Chris. We do have several questions here. And I will start with, let's see, if a management company were to offer a rent payment plan for residents who are late on rent for April or beyond, would we be able to ask for specific documentation that their need for this assistance is COVID-19 related, proof of job loss, receipt of unemployment, et cetera? Or would this need to be open to anyone who is late on rent, regardless of whether this is COVID-19 related?
Well, so just reading the order from yesterday, it's clear that you're going to have to involve a COVID-19 related component in some form or fashion, because that's the definitional criteria. So if you are giving people a forbearance from an eviction proceeding because of the effects of COVID, there has to be a way to determine that. So I think that's almost certainly going to become part of the issue. The question of how you do it, or when you do it, or in what capacity you do it. I think there's a lot of legal issues that you're going to need to seek counsel on, because the Fair Housing Act hasn't been suspended. The Fair Housing Act says that you can't offer people of one category a certain benefit and not offer it to others. And so if you are contemplating doing a payment agreement opportunity, you are going to need to get some real clarity from counsel as to what the scope of it is, how you communicate it, how it's offered, when it's offered, because the Fair Housing Act still applies. And so treating different people differently, things like saying, well, if they ask for it, we'll offer it. Well, that's not a good idea, because if then you're wondering, how did they find out about it? Do some of your staff members whisper to their friends that live in the community, hey, by the way, if you ask for it, we are going to give you a payment agreement. But so only they are the ones that get it. Your staff told them that, but if the word of that gets out, then that would be a huge problem from a fair housing perspective, from a discrimination standpoint. So there's really a lot of issues of how do we set it up? What's the one size fits all answer? Is there a one size fits all? If not, how do we set it up? Otherwise, those are all hugely important issues that are impacted by so many factors relating to what kind of financing do you have at your property? What kind of property is it? Is it multifamily, single family, big, small, federally funded, not federally funded? There's just a lot of questions that you'll have to talk through. But the truth of it is that payment plans are definitely going to be an issue. It's not rumor, it's pretty confirmed fact is that NAA is in the process of putting out a national payment plan agreement that can be immediately implemented as part of its lease program. There's no information that I know of yet as to what the timing of that is, but I'm sure it's being given super high priority, so I would expect it soon. And so those sorts of things, the key is to make sure that if you're entering into any sort of agreement that modifies any part of the contract, such as how much rent is due this month, when are other amounts due, those are all agreements that ought to be in writing. And in fact, if you're using the ANC lease or the NAA lease, they have to be in writing if they're going to be enforceable. They won't be enforced by the court if you don't put them in writing and sign by all parties that signed the contract. So those are standing items that you'll have to address. But yes, there's going to be a lot of that. Trying to verify COVID-related information ought to be fairly straightforward because of the very clearly delineated timeline of events that's gotten us here. Basically March 1st and after is pretty easy to spot what the issue is, but losing your job, having your wages reduced, losing hours, those are all things that ought to be very easy to identify when you figure out what program it is you're going to have in place. That kind of information ought to be very easily accessible for the vast majority of people that might have a need. But for other people, if their income hasn't changed, if their job hasn't changed, they're still showing up to work and getting paid, then there's no reason why you should have to change how you operate for them.
Okay. And one point of clarification on the NAA click and lease, we did get an email. It hasn't, I don't think they've publicly 100% committed to this, but I think the target date for that click and lease for the payment plan document is April 1st, I believe. But again, I think that's a target date. I don't think that's something they can say for sure yet. Another question, for single family homes, would it apply to all the owner units, or what type of documentation should a landlord request? So in other words, is it only the, it sounds like they're asking is if it's all the owner units, whether or not they, depending on which kind of mortgage they have?
Yeah. The federal HUD-based suspension of evictions for 60 days applies only to single family properties and only if the owner has an FHA insured mortgage. So the question you have to ask is, what kind of mortgage do you have? If you don't know, then the owner has to tell you, And that way, whether it's FHA insured mortgage or not. Because if it's not, then it doesn't fit the criteria. But if it is, then that property has to be taken out of the list of properties for which an eviction might be filed.
Okay. Let's see. Next question, and they're coming in fast and furious. So I'll try to call them as best I can. I think you might have addressed this already, but maybe we can do it again.
Yep.
What type of support documentation are we allowed to ask the resident to provide that they are terminated due to coronavirus?
Well, it's not what you're allowed to ask to provide. Like, there's no, none of these guidances dealt with that. The issue really is much more about who are you asking. And so, to me, providing confirmation of that depends on first figuring out what is your program going to be. But at the end of the day, it's going to be a challenge to figure out exactly how that is, because if your property is one of the multifamily properties that meets the FHFA order from yesterday, then it seems to pretty clearly indicate that there's going to be a broad standard as to whether the tenant was unable to pay rent due to the impacts of coronavirus. Well, that doesn't say because they lost their job. That doesn't say because they had their hours reduced by more than half. It says they can't pay the rent due to the impacts of coronavirus. There's no way to know what that means. They didn't define it today, and so you're going to have to reach out to get guidance from every possible corner of the universe you can, NAA included, your local council, your general counsel at your corporate entity. But the program you put in place is really going to kind of documentation you request. It's not what kind of document can we ask for is putting the cart before the horse. You need to figure out first what your program is, and then you can figure out what you need in response to your program. But yeah, there isn't anything that says you must request this documentation. So before you get even to that question, you should figure out what is the program we're going to be offering, and then what documentation are we going to ask for.
Okay. I've got a couple of questions that are similar, related to evictions that are they're not related to non-payment. And have you seen recent cases of these types of evictions, and are they able to still escalate removal of tenants due to behavioral safety concerns during this time period?
There are no hearings being held, none, unless it meets the criteria of an emergency operation of the court, which would include things like personal safety, domestic violence protective orders, restraining orders, and things of a criminal nature. Then the answer is no. We don't have any guidance from the court in North Carolina that provides for any exemption other than for the certain limited criteria, and none of those are eviction related issues. If there was a need for a personal safety, if there was a need for a warrant for someone's arrest, if there was an actual threat being communicated, that's a criminal matter, and those things are still addressable as criminal matters. Protective orders are still available for safety and health protection, but evictions are not the same. So no, the court does not categorize certain criteria of evictions as being a special set, like it does for things like domestic violence protective orders and criminal warrants and arrests and charges.
Okay. Two other related questions here regarding late fees. Any suggestions you have regarding late fees, best practices for waiving them, waiving existing fees for online payments, partial payments, and the like?
Yep. So it's really all part of your plan. Late fees are, if you're going to be offering people some sort of partial payment plan, then late fees would obviously be included, or should be included as in some form or fashion. So how you do that depends on what your protocol is going to look like. But if you're going to develop one where you allow people to work out a payment arrangement for a past due balance, then the issue of whether you charge them late fees or whether you don't, or in what situation you charge them late fees, is all part of the agreement, because your lease says that you're going to charge late fees. So to change that, you have to have that as part of a written agreement signed by all parties in order for it to be made different. You can always choose not to assess a late fee, but if you don't have a specific protocol in place, if it's not part of your whatever partial payment plan you're going to put in place for your property, that's a lot of P's. If it's not part of that, then you run the risk of it being a fair housing problem. Again, you can't just suspend some late fees for some people without having a very clear business delineation as to why, when, and under what circumstances. So all of it should be wrapped up together. Honestly, all of these issues should be dealt with as part of one universal whole. Here's what our property is going to do in regard to modifying standing lease obligations in full. All of these issues will be addressed in one document, in other words.
Okay. A couple of questions here on timing issues. One is somebody says they have a court date in March 25th in Guilford County, asking if it'll still take place. I think I know the answer.
They do not still have that court date. That court date has been continued automatically. Whether they've received the new one or not, they do not actually still have that court date.
Okay.
There are no court dates prior to April 17th as of today.
Okay. Someone else mentions that they're in Wake County. They have 3 writs that would normally be filed today. Based on what they understand, even if they attempt to file, the lockout would not even occur until April 17th or later. Would it be best to not attempt to file these at this time? Just hold off.
I think there's no reason not to attempt to file them. I think until such time as the clerk makes clear or the Chief Justice makes clear that they're not even going to accept new writs. I think it's one thing for the sheriff not to execute them, but I don't think there's any reason why the clerks shouldn't accept them. So I would say that they should follow their usual protocol with regard to requesting a writ be issued by the clerk. And if the clerk sends it back to you and says, I'm not going to, then they send it back to you and say they're not going to. But I don't think there's any reason not to keep pushing the issue for the time being until we get clarity from the Chief Justice. Because, really at the end of the day, there's not any skin off of your back, no matter what you do. If you send it to them and they send it back, it's not like they took your money but didn't issue the writ. They're going to send the money back with it. So I think it's probably better practice just to keep sending them in hopes that, if nothing else, maybe the clerk will get sick of getting them all and change their mind.
Okay. Let's see. We have different kind of question here for FHFA loan forbearance. Will we have to prove that we are negatively affected by the coronavirus?
That's what it says. All I can do is read the language, but the language did say that you're entitled, that the property owner is entitled to receive the forbearance on its mortgage obligations if it is in fact negatively impacted by the coronavirus. So it didn't specify what's the standard. I'm sure that if in coming days and weeks, that the agency will likely issue some clarifying guidance out there, or at least will respond to inquiries from owners who qualify. But in a public release, press release like that one, it just doesn't have enough information in it for us to know much today without waiting for further clarification.
Okay. How
how they're going to administer it, what they're going to be looking for, what the criteria might be. They left all of that out. It's a press release. There's only so much they can put in it.
Okay. Another interesting question, I think for all of us, and that is, for a single family property management company, would they be considered an essential provider as just like a multifamily management company?
Well, the answer is that it's completely possible. It's also not, because the governor's order can say anything. The governor can decide what he's going to say. The governor will decide who he's going to include. And so, if in the state of Georgia, they left these issues up to the cities, I think. And so each city has its own directive, which may be different. So it may also depend on where you're talking about. You may get different orders from different places. Each county in North Carolina has the power. The county health department has the power to issue a shelter-in-place order of their own if they want to. And so you may have one county where there's a particularly big outbreak, and they may give a shelter-in-place order, and that may be controlling for that county, but that's it. So, if you're in Raleigh, you may have to do one thing, but if you're in Chapel Hill, you may be allowed to do something else for a period of time. If the governor isn't taking universal action, then you may still have patchwork counties that are addressing their particular situation with shelter-in-place orders, and they can say whatever they want. So you have to stay on top of it. You just have to figure it out. based on where your office is located.
Right. And so to follow up on that, as you mentioned, A and C just came out with a letter to the governor asking that the industry at large be considered essential. And then some cover email, there was language that is suggested for each company to apply, and an email address to apply for the essential provider status. And what you're saying though is even if it doesn't go statewide, if a county does that, our members might want to be prepared to go to the proper entity within their county if a shelter in place is issued to get clearance from them. Okay.
Yeah, the county health department, and the chairman of the county health department is the one who has the power.
Okay.
Or the director.
In order to minimize the possible spread of COVID-19, is it possible for us to not take any payments in the office as long as we have the option to pay via WIPS, which is a similar cost to purchasing money order, online payment options through resident portal, ACH is free, debit and credit card is an average of 2.2% fee. So I guess the question is, do they have to take it in the office?
Yeah, the answer to that is it depends on what you contracted to do in your lease. Most leases have a lot of flexibility in terms of payment arrangements and gives you some power to deal with that. But refusing to take a certain type of payment out of the blue isn't something that you have the unilateral power to automatically do. So you'll likely want to review your lease provisions, and every lease is slightly different in how it addresses that. And so there isn't a one-size-fits-all answer for that question. But as with everything else, you can't change the terms of a lease without everybody agreeing to it in writing. And so if a resident says, I'm elderly and it's a real burden for me to have to do all this stuff electronically because I'm not savvy, and it's just much easier. I live right next to the office and I want to be able to bring you my check. You would have to think long and hard about that, especially since that would involve an overlay of reasonable accommodation requests and things of that nature. So I think there's just a number of issues that have to be dealt with on a lease by lease basis, or at least, what type of lease are you using at your community? What does it say? And then analyzing that to determine what are our options here in terms of trying to make changes, minimize risk, help people out, help people stay safe. But you can't just decide to suddenly change. That's not typically part of anybody's lease.
Okay. Next question is, we're planning to waive all late payments, but sending a late notice on the 6th and telling them to contact us if they need rent payment agreement due to COVID-19. Will this work?
Well, I can't give specific legal advice to just random people on the web, especially since I don't know what your lease says, and whether you're allowed to do that or not I'd have to read it and make sure that I understood it. But conceptually speaking, there's no obligation to provide a late notice at all under most leases at use in this state. Late notices are sent as a courtesy, not as an obligation. And so if you choose to send a different one than what you normally send, there's nothing wrong with that under the vast majority of leases used by everybody in the industry. NAA lease, ANC lease, the realtor's lease, all waive the right to any notice at all. So if you're sending a notice, it's voluntary. So changing that notice is not generally a problem. The question of what you include in it, though, is one that you would have to deal with property by property and make sure that you got the content that you want.
Okay, good deal. So we have a couple more here I think we have time for. Okay. For appeals in process, do those residents still need to make their payments to the court, or is that also postponed?
The obligation to pay is probably going to be deemed postponed until April 17th. If I don't think that there's any question that as it relates to the tenant, that the Chief Justice's order applies because they're a party to the case, and her order of the 19th says that for all parties, for any actions taken by a party or that are required to be taken by a party, those deadlines are deemed satisfied if the action is taken on or before April 17th. So I think that a resident probably can skate for the moment, probably can miss the deadline in early April. As long as they pay by April 15th, they would probably be deemed compliant.
Good deal.
That'd be my guess. Hasn't happened. Yeah, we haven't addressed it yet, but I think that's probably how it would go.
Okay. For those who file through Nationwide, assuming we're not asking for forbearance, do you recommend us still filling in Nationwide so your business can be ready when core business returns to normal hours?
Since the clerks of our counties are still accepting new filings and still scheduling them for hearings, the question really is, do you want to get your place in line now, or do you want to be at the back of the line later? I mean, they're continuing to schedule hearings every day, just like we do, other than the fact that they're scheduling them much farther out. But as normal, the later you are in submitting your case to the courthouse, the later your hearing date will be. So, I mean, to me, it's really a matter of, where do you want to be in line? Do you want to be in line now, or do you want to be in line at the back of the line later? So yeah, I think the pragmatic thing to do is to keep filing cases on people that have an obligation to pay and don't have a good reason not to, or haven't taken you up on any sort of payment arrangement plan you might put in place for COVID victims. But otherwise, yeah, delaying filing your cases in North Carolina doesn't make any sense from a timing standpoint. You know, you can't get the case heard, so nothing bad's going to happen to anybody who's a tenant for the time being anyway, but you're not sacrificing your place in line unnecessarily by just waiting around and doing nothing.
Okay. A couple of related questions here, slightly different, but I'll try to package them together because we're running short.
Yep.
One question was that they received their court dockets that were for the month of March. They were scheduled for March 20th, and they just received the documents in their mailbox this morning, backdated. Knowing that the courthouse is working with limited interaction and hours, question is if we have to file again for the month of March or wait until after April 15th. That was the first question. The next one was, once all this gets settled down, how can we file eviction? Should we file for the entire balance, or should we file for just the month that we are filing at the time? So those are some.
Oh, that'll be interesting. Yeah. So if you got something from the courthouse that says your case has been filed, then there's no reason to file again. You already have a complaint that's in place. The hearing will be scheduled eventually. So there's no reason to file twice on the same person. But in regards to what to do later, again, if you're continuing to file your cases as you go along, you won't have to worry about that. If you're forbearing on all of your evictions until later, then I wouldn't even venture to guess what the rules might be by then, because there's any number of possibilities that might come to play. Whether there's federal forbearance that comes down the pike at some point, whether people get federal aid that allows them to have their rent forgiven for some period of time. Everything's up in the air. All of the options are still on the table. Rent forgiveness is something that a lot of people are pushing for. I don't know how much traction it's getting, so there's just no way to know. That's why I think filing as you go for your usual protocols for people that don't have a reason not to be filed on is the way to go. Just stay current, do what you always do for the people that you know should have paid you rent but didn't. That way you don't have to worry about guessing later, is this a good idea? I think if you just stick to your usual protocol, with the exceptions of anybody who's getting an exemption because of COVID-related problems, I think that'll be your better bet.
Okay. Real quickly here.
Right.
Question was asked if it's recommended for the management company to issue some kind of notarized letter for employees. This is for the essential business proof. So in case they're pulled over by a state trooper, they can prove that they are working for an essential provider. So I've seen, we've seen in our own affiliate, from other industries, we've seen letters to, like, some of our members' spouses who work in other industries. They have a document, an official document that says so, but I haven't seen anything for our industry. Just wondering if you have.
No, I haven't seen one yet, but that's, I think, largely because we don't really have shelter-in-place orders in either North Carolina or South Carolina yet, and so it just really hasn't come up. But I certainly think that if it gets to that level and there is one that's put in place, I certainly can't imagine that that would be a problem. And it certainly would be a nice thing to do for the people that you're asking to come to work, is to at least make sure they don't get pulled over by a trooper.
Yeah, I agree. I
Yeah.
agree.
Yeah. It seems like an easy thing to do. Form letter that just changed the name and, cut and paste a new name into the form letter. It seems pretty simple.
Yeah, I agree. Meg, how are we doing on time?
2:03 says my clock.
Okay.
We're good if Chris is good.
Yep.
Okay. Okay, Chris.
Right.
A tenant for a multifamily complex will only have an expectation, I think this is on the rent forgiveness forbearance thing, if the owner has an FHA
Yep.
loan, right?
The rent fee, Fannie or Freddie. Yes, multifamily properties is a Fannie and Freddie forgiveness issue. So only Fannie and Freddie properties are eligible to ask for forgiveness, and so yeah, those communities, the residents only get forgiveness if the owner asks for forgiveness themselves. So if the owner asks for mortgage forgiveness, then they have to agree to let the residents who are impacted and can't pay their rent because of COVID, they have to let those residents not get eviction filings.
Right.
So it's going to be a multi-part analysis.
And I think the challenge for our members is going to be that what the public sees is that there's the government has said that there's loan forgiveness. That means that there's going to be rent forgiveness as well. Not understanding that there's types of properties, and that's
right. Yeah.
So I think that's going to be a communication issue for a lot of our members until this gets broader.
That's right.
Two more questions real quick, and then we'll call it a day. How are companies like Nationwide able to still file new evictions to get in line if the courthouses are closed? Is it done?
Courthouses aren't closed. Courthouses are still open and functioning for business today.
So it is electronically, basically, is probably the best way.
Well, yeah, I mean, everything that's done at the courthouse, no courthouses in North Carolina yet operate electronically, so all the paperwork documents have to be submitted the same as always.
Okay. And then last question. In our case, the court date already passed in Mecklenburg County, but we were not notified until after the court date, which was March 20th.
Mm-hmm.
I guess the question, and that's what they type. So I guess the question is,
it doesn't matter. Your case was continued by order of the court, and you haven't received notice yet because they don't know when it's going to be rescheduled.
Okay.
But all the cases were continued by order of Chief Justice Beasley on March the 15th. That Sunday night order said that every case that's pending before a magistrate is ordered continued for at least 30 days. But as of right now, I think most of the cases that were continued haven't yet been determined when they're going to be rescheduled yet.
Okay, great.
All right.
Any parting thoughts, Chris, before we?
No, I think everybody just sit tight and keep working with your counsel to try and figure out the best plan for your particular property and your particular situation. There's such a great variety of different approaches among the multifamily industry clients of the associations that there's not even close to one size fits all answers. Every property, every owner probably has their own plan, their own criteria, their own desires and wishes and wants. And so I think you're going to have to just really work hard from the management side to work with all those things and try and develop a protocol that works for at least each property. But yeah, stay tuned because there's going to be more information that comes down the pike between now and Friday, if I have to guess.
Okay. All right. Well, Chris, thank you again for doing this. Again, thank you to all the affiliates for helping pull this together. Meg, thank you for all the work you've done on this. I think I neglected to introduce myself at the beginning of this. I'm John Louder. I'm the executive director for the Piedmont Triad Apartment Association. It was our pleasure to kind of help play host for this this time around. There will be a recording of this on YouTube as soon as it takes a while for Zoom to download this and for it to get converted and then get it onto YouTube. But once that happens, everybody will get a link. And I believe we are doing this again on Friday. Is that right?
Yep.
All right. We're doing this again on Friday. Details to follow.
Yep.
Everybody, if you have questions, if you have more questions, feel free to reach out to your local affiliates. We're working very hard to try to address all the issues that are arising out of COVID-19. It's a fast moving and very dynamic situation right now. So stay tuned. Thank you all for joining us, and look forward to seeing some of you again soon.
Thank you, John. Thank you, Chris.